Good afternoon, everyone. We're just going to give folks another maybe 30 seconds or so to finish logging into the webinar, and then we will get started. Okay, I think we're going to go ahead and get started. Good afternoon, everyone, and welcome to today's webinar. My name is Michelle Peterson, and I am the Senior Training Manager for the Empire Justice Center. First, I do need to note that today's webinar is made possible by the Legal Action Center and the New York State Department of Health AIDS Institute HIV Education and Training Program. Before we get started, just a quick note on how you can interact with us today. Today's webinar is being closed captioned. You can find that link in the chat, your control panel. If you want to take advantage of that, you can do so. Everyone has entered the webinar in a listen-only mode, so if you have any questions on the material that's being presented during the webinar, enter your question using the questions pane, which is also located on your control panel. We'll be addressing questions during the presentation, and we'll allow some additional time at the end of the presentation for questions as well. The materials for today's webinar can be downloaded by going to the handouts pane on your control panel. Here you'll find a copy of today's PowerPoint presentation and a manual that we hope you will find useful. At the end of the webinar, you'll be asked to complete a webinar evaluation. So if you can take a moment to complete that, we would greatly appreciate it. So we're going to go ahead and get started, and I'm just going to briefly introduce our presenter today. Our presenter is Jennifer Carr. She is our senior staff attorney in our disability law unit. So I think I'm just going to go ahead and turn it over to Jenna right now, and she can get started with our presentation.
Thanks very much, Michelle. I want everyone to know that if they have any problems hearing me today, please make note of it in the chat or in the question area, and I will try to speak louder. As Michelle mentioned, I am a staff attorney at Empire Justice Center, which is a New York statewide legal services provider. And we provide training for all different topic areas in New York State for legal services advocates. And we also directly represent clients. And my practice is specific to the disability law unit that we have, or commonly known as DAP, Disability Advocacy Program. I've been practicing in this area for about 10 years. And within our unit, we have the statewide trainers. We also have advocates who represent clients in Rochester, New York. So that's where I'm located, in Rochester. But we train and work with advocates in the disability program throughout New York State. As Michelle mentioned, we have two handouts today. I'm going to be talking primarily from the PowerPoint, but also referring you to the manuals, certain areas or pages that I think would be helpful, especially during the presentation. I want you to feel free to ask questions at any time as well. The goals today are really to give everyone a basic overview of the disability program that's administered by Social Security Administration, and an idea of the types of benefits that your clients could receive through this program. We'll be giving tips on how best to apply, how to kind of put your best foot forward when you're filing an application for your clients. And we've provided in the manual reports specific to HIV as a disabling condition. So there are very specific reports that Social Security uses for claimants who have HIV/AIDS. Okay, so getting into the overview of the program, there are two different types of disability programs. The first one that I'm going to talk about is Social Security disability. That is a program that we, when we are working, we pay into the disability program. So the taxes that are taken out of our paychecks in part go to this program, and after you work a certain number of years and get a certain number of credits based on your income, then you qualify for Social Security disability if you become disabled under their rules. Now, it's generally a 10-year period that they look back to see whether or not you've worked enough. And in this program, there's no income limits. Anyone who has become insured with those work credits is eligible. You can be a multi-millionaire and receive these benefits that you paid into the system for. The other program that is available to disabled individuals, individuals with disabilities, is the Supplemental Security Income Program, or SSI. Now, this is a needs-based program. So it is for people who are 65 years of age or older, or any age who are blind or disabled, and that includes a childhood SSI program. It provides a monthly cash benefit, as the other one does. The SSD program provides monthly cash benefits from the federal government. This is a chart that we refer to just to give you an idea of how much individuals would be eligible for if they are on, if they're found to be disabled and eligible for SSI. SSI is a very low monthly stipend. It doesn't even get people out of above the poverty level established by the federal government. So it's a very small amount. Most of our clients in Rochester are SSI eligible, which means that their income is extremely low. And the vast majority of our clients are receiving benefits from our county, so public assistance benefits. The advantage of getting on SSI is that your benefits double as compared to what you were getting on public assistance, but it's still just barely making it for people. In that first line, you can see that the living alone rate for an individual is $794 a month. So that is their, that's how much cash assistance they get from Social Security. Now, in the other program, SSD, the average monthly benefits are it's based on how much earnings you have in your history. So it ranges, but the average for SSD benefits is about $1,400 a month. So a significant difference between the two programs. And if you look over to the next column where it says state benefit individual, that's what's called the SSP benefit. So it's a state supplemental program benefit. And each state has the option to provide an additional benefit to people who are on SSI. New York State chooses to do that. There are some states that provide a higher benefit, but New York State is one of the higher benefit rates in the country. And as you can see, it's an $87 per month benefit, which brings an individual up to $881 a month. Now, sometimes we have couples, married couples, or people who are holding out as married and are both disabled for SSI purposes, they actually reduce, so you're not, as a couple living together, sharing resources, you're not going to get double the amount. So you're not going to get $1,600, $1,700. They're going to reduce that rate because their explanation is that you share resources, so it's less expensive to live. So you can see that is a very low amount, again, for a couple to live off of, $11.91. And then they also are eligible for the state benefit of $104 as a couple. So in total, a married couple who are both on SSI are eligible for $12.95. Now there's other categories for SSI. The next one is the next most common is living with others. And that doesn't affect the federal rate, but it does affect the state benefit rate. So New York State will only pay people $23 a month if you're living with others in the same household sharing resources. And again, with the couple rate, they're going to reduce, New York State reduces that as well. The third category is fairly common, although what we see are clients who are in this category, but there are ways to get them out of this category and get them into the higher rate of living alone. So if you're living in the household of another, the way that that's defined by Social Security is that someone is providing support to you. So if you're living, for example, we have a lot of young adults who live with their parents and may not pay room and board or rent. And so they reduce their individual rate down to $529. And that's because they're saying, you know, this is a needs-based program for food and shelter only. If someone's providing you with that benefit, then the government's not going to pay for it. So that is one of the most common problems that we see are people living in the household of another with that reduced rate. Now there are ways to fix that if you have an agreement. For the example of the adolescents, the young adults living with parents, if you have an agreement with the parents that you will pay them room and board, then you can get bumped up to that higher rate of $794. And then below, those are the three most common categories, people living in the community. And then there are congregate care levels, so people in supported housing. There are different rates for individuals living in supportive housing. And this is the 2020 benefit rates, which, as you can see, went up. 2021 went up $11. The non-disability eligibility requirements, which are the financial requirements for these benefit programs. Aside, the disability eligibility requirements are those medical eligibility requirements. So for SSD and SSI eligibility, for SSD, as I mentioned before, it's not based on need. You can have resources and finances, cash available to you. It doesn't matter for SSD. But for SSI, it's a very strict definition and amount of cash and resources that an individual can have and still be eligible for SSI. So basically, they have to have little or no regular cash income or resources that they can turn into cash. There's different types of income for Social Security that will potentially affect your benefit rates. Earned income, which is primarily if you're working and you're making wages, that is the most common type of earned income that Social Security looks at. The next is the in-kind value of food or shelter, which is that category of living in the household of others, and they are providing some sort of benefit to you by not having you pay for food or not having you pay for shelter. Social Security will count that against your benefit, as I mentioned. And then for self-employment income, they will consider net income, earned income. Even sheltered workshop earnings are reviewed and can possibly affect your monthly benefits, and royalties and garnished funds, which we don't see a lot of. So there are exclusions for earned income when Social Security is calculating how it will affect your monthly benefit. For SSI, they do not count tax refund payments, and there is a general $20 disregard that is that can be applied to your earned income as well. And then once you use those first two, if you're using those first two exclusions, then Social Security will disregard $65 per month of your earned income, and then 1/2 of the remaining earned income in the month. The different types of income that Social Security looks at are the unearned income, which is basically all income that's not earned. And then there are exclusions to the unearned income, which are very specific programs that are funded by the state or the city, disaster relief assistance, and if there's any interest on burial resources. So if you have a burial fund that is earning interest, that can be excluded. And then there are also non-income items that Social Security does not count as income. That includes medical care and services, clothing, income tax refunds for a specific amount of time are not counted against you. And then money borrowed as a loan is not counted as income. And then also, if you're getting paid back for a loan that you gave to someone, that is also not counted as income. The resources this is something that, not only is the benefit rate very low for individuals to survive on, but then you are limited in the amount of resources that you can have and still be eligible for SSI. It hasn't changed in decades, the amount. So it's a very, very strict limit. And for an individual cannot have more than $2,000 basically in cash resources, something that's readily available. For example, in your bank account, you cannot have more than $2,000 in the bank account at any time or at the end of the month and be eligible for benefits the following month. And the definition that they use is resources are cash or other liquid assets, real or personal property that an individual owns, and that they could convert to cash to use towards their food or shelter. Liquid assets are considered anything that you can turn into cash within 20 working days. And then the non-liquid resources are property that cannot be converted within 20 working days. And the non-liquid resources are more commonly property that you own, I think the most common one that we see is real property. So now I want to talk a little bit about how one goes about applying for benefits, and hopefully we'll give you some tips, and there are forms in the manual that we provided that should help out if you're planning to apply for benefits for your client. The most commonly, people would go into the office to apply for benefits, either SSI or SSD disability. Now the offices have been closed since March of 2020. So the local offices that people used to go into for service and help with smaller problems, those have been closed, and you're only able to reach Social Security with their 1-800 number or with their the local office number as well. So this has made it, in my experience in the past year, has made it very difficult for clients who have barriers to understanding. If there are clients who have intellectual disabilities or have language barriers, this has made it very, very difficult for them to get service from Social Security. Fortunately, we haven't heard of any plans to reopen the offices, and now that the cases are going up, it's probably going to be delayed even more. So, so their options are to call the 800 number if they're applying for SSI. If they're applying for SSD, which is that insurance program that people pay into while they're working, those applications can be filed online at ssa.gov. But the SSI applications cannot at this time be filed online. So that's what's made it most difficult for our clients, is that they can't just go in and bring their paperwork to someone at the office to help them with the application. So what do you need to complete your application for SSI or SSD? For SSD, well, the basic information that you need is obviously a Social Security number, your contact information, name, address, telephone number, and knowing which program you're applying for. So if you have a client who has a long work history, chances are it will be for the SSD program. Some of our clients have worked many years, but in lower wage jobs, and maybe they had a break due to their disability and didn't work for several years. Those clients can sometimes be dual eligible. So they may get some money from the SSD program and then some money from the SSI program. So you have to, if client has any work or income in the past 10 years, then I would make sure that they're applying for both programs. When you apply for SSD, Social Security will want to know a very detailed information on your work background, and then also very detailed information on the types of medical treatment that you've received, including names of doctors, names of medications, tests, diagnostic tests that they've had done, like MRIs or X-rays, CT scans, any sort of lab work that you think may be relevant to their disability. Social Security will want to know where they had those tests done and the dates of the tests. And some of this obviously will be approximate dates and information, but especially at the initial application, you want to be as thorough as possible so that Social Security can get medical records and information from doctors and hospital systems that will help them make the determination. One thing to note is that an application for SSI is automatically an application for both disability programs. So if you're applying for SSI online and Social Security sees that you may be eligible for SSD as well because you have a work history, then they will process an application for both programs, because basically they want to pay you benefits from the program that you paid into. That has, the trust has money from all workers who have paid into it, whereas the SSI program, the need-based program, and the funding for SSI is based on congressional allocations, where SSD program, they actually have a pool of money that they're receiving every time paychecks are issued. Once you file the application, either online for SSD or by phone for SSI, your case is sent to a disability analyst who will look at the basic information that you provided, the reports and forms that you submitted, The disability analyst will also obtain medical records from your doctors. So they will be reviewing and analyzing the medical records and the information that you gave in your application to determine whether or not you qualify for disability. Usually takes about 3 to 5 months for a decision. During the pandemic, I think we've, at least up here in Rochester, we've been seeing that those have, that time frame has really not changed too much. So it's still, I would say, 3 months for a decision. Then during that 3 to 5 months, most claimants, most clients will be asked to go to an appointment with a Social Security doctor or a Social Security psychologist. And those appointments are called consultative examinations. The examinations and reports that are produced after the exam are made part of the evidence. So a doctor will will examine the claimant, go through all of their answers to questionnaires that they complete before the appointment. They will do limited amounts of testing. If it's a physical impairment, they will do a series of exams, having them do smaller things like squatting, stooping, being able to button a button. Those types of smaller exams will be used to complete a report. And the report for the physical examination will include their doctor's opinion about what limitations or what restrictions this particular claimant has. So if they are unable to lift, for example, more than 10 pounds, that doctor will make a note in the report that they are restricted in their ability to lift and carry. The same goes for the psychological exams. Those restrictions are usually related to an individual's ability to interact with others, an individual's ability to maintain attention and concentration, or their ability to interact with others, but also to keep to a schedule, keep showing up on time for appointments or for work, or whether or not they will have number of absences per month. So the psychologist, after a brief exam with the client, will give a report with their opinion on those limitations. We suggest that you always respond to requests for information from Social Security. You will receive multiple iterations of the same forms throughout this application process. I would say that the initial reports and forms are the most important. You want to have them as detailed and complete as possible. But then subsequent forms will ask for the same information over and over. And if it hasn't changed, if the medications haven't changed, if there's no new test results, if there's no change in the doctors, you can be a little bit less specific and not repeat the same exact information over and over. But if anything has changed, make sure to respond and give them that information. If the application is denied, a client has 60 days to request an appeal. And that request must be in writing. So there are forms that they will provide you in the letter of denial that you can fill out and send back. We always suggest getting a fax confirmation or having a certified mail receipt. The other, when the offices are open, if someone goes in to submit this form, we suggest that they ask the analyst or the customer service representative at Social Security to give them a copy with a date stamped on it when it was received at Social Security. Sometimes not often, maybe, a moderate amount of time, the information or forms can be lost. And so you want to have receipts when that happens. So let's talk a little bit about how they actually determine whether an individual is eligible. Now, this is for SSI applicants. They initially do the financial eligibility for them. So once you make it past that point, then they're going to do a medical eligibility determination. The way that Social Security defines disability is different than other types of disability programs. They have their own unique system and regulations that prescribe how one is found to be disabled. It is different from the VA programs. It's different from workers' comp programs. It's just different from the New York State disability program as well. So we've provided you with the definition and the method that Social Security uses to determine whether they are disabled. This is the definition that they use, and then they created a sequential evaluation from this definition. So as you can read along, it is the inability to perform substantial gainful activity. Substantial gainful activity is a monthly amount of income that an individual generates. It's around $1,200 a month. And if an individual is working and earning more than $1,200 a month, they will be found that they are able to perform SGA, or substantial gainful activity. And that will immediately knock them out of being eligible for this program. So assuming that they're not able to perform SGA, then the reason has to be because they have a medically determinable physical or mental impairment. They can also have a combination of impairments. So many clients have physical limitations, arthritis, fatigue, side effects from medications, those types of physical limitations, and then also have severe mental impairment, most commonly depression, anxiety, PTSD. Those mental health impairments can be combined with the physical limitations and must be considered by the adjudicators, by Social Security, when they're deciding whether or not an individual is disabled. So you don't go in with just one reason or one diagnosis that makes you disabled. If you have multiple impairments, they need to consider the combination of the impairments and how it limits your ability to perform substantial gainful activity. There is a 12-month duration requirement. So these limitations have to have existed 12 months already, or they're expected to last at least 12 consecutive months or end in death. So a person with a terminal illness would qualify and doesn't have to have that 12-month duration period. Now, the final part of this definition is that Social Security takes into account the individual's age, education, and work history. So if they get all the way to the end of the sequential evaluation, which I'll talk about next, Social Security will consider if an individual is very young, if they have a higher education, and a work history that they could, if they've learned skills during their work history that could transfer to other types of work that they may be able to do with their physical or mental impairment, then Social Security will consider that. It becomes easier as an individual ages if an individual has a lower level of education or a lesser amount of work history. It generally becomes easier to be eligible for disability. as I mentioned, there is a sequential evaluation that Social Security uses, which is a five questions that they answer to decide if someone's disabled. They must be answered in order, and if Social Security can make a decision at any step, then they don't reach the next question. So the first is, are you working? And if you're working and making above that approximately $1,200 per month threshold, then you will not be eligible for disability. If you're not working or not making that amount, then they continue to the next step or question, which is, do you have a severe condition or combination of impairments that keeps you from working? And so at that step, Social Security will look at the medical evidence to see whether or not there are diagnoses by medical doctors or psychiatrists, psychologists. If there are diagnoses in the record that can be considered severe, or the limitations that they bring are severe. So if you have at least one severe condition or combination, then you move on to the next step, which is, does the condition or conditions, does that appear on Social Security's listing of impairments? Now, the listing of impairments is basically all of the physical impairments that they will consider, all of the mental impairments that they will consider, and use of definitions and criteria for meeting what we call meeting or equaling the listing of impairments. So if there is a condition that appears on that, Social Security will evaluate whether or not an individual meets all of those conditions. A way of looking at it is something like a recipe. If you have, for example, HIV/AIDS, which we're talking in the context today, do you have all of the criteria that Social Security wants to see? Do you have all of the ingredients of a recipe to make you eligible? And those impairments can be found on the SSA.gov website. I would say that in our practice, perhaps 20–25% of our cases meet this listing requirement. But if you don't meet the listing, again, for example, HIV/AIDS, if you don't meet that listing, it doesn't mean that you're not disabled. It just means that you have to keep going through this sequential evaluation. So the fourth step, if you don't meet that listing, you will be asked whether or not you've worked in the past, and Social Security will decide whether or not you can do the type of work that you previously did. So that is why when you're initially applying for SSI or SSD, that you're very specific about the type of work that you've done in the past, all of the requirements and that you had in that job, the responsibilities that you had in that job. And when you're talking about physical labor or physical work, you want to be very clear about what your client actually did on the job. So if they were often lifting 20 pounds or more, you want to make sure that they indicate that in the forms that you fill out. And sometimes people have a difficult time estimating the pounds, the amount that they stood, but you just want to really flesh that out and get the best idea of how that job was performed. If Social Security determines that you're not able to do the past work, which is often happens because clients would be working if they could do that type of work, if Social Security determines that they can't do it, then they move on to the next step, which is, can they do any other type of work? So, for example, if you had a client who did very heavy labor and has a physical injury or impairment, they can no longer do that heavy work. Are there other types of work that an individual like that could do? Would they be able to do light work where they're mostly standing, but there's limited amount of lifting and carrying? Could they do sedentary work where they're mostly sitting, working with their hands and not with their feet, very limited standing, walking? So if you can do other types of work as determined by Social Security, then you would not be eligible for disability. So just to talk about steps 4 and 5 a little bit more, as I said earlier, the older you get, the lower education that you have and the less past relevant work experience that you have, the more likely that it is that you'll be found disabled. And a judge or the disability analyst will determine what your residual functional capacity is. So the residual functional capacity is what an individual is able to do when all of the limitations have been considered. So if someone cannot lift more than 20 pounds, that will be part of the RFC, the residual functional capacity. And the judge or analyst forms this RFC and then applies also their age, education, and past work experience to make a determination about whether they can do their past work or whether they can do any other work. So question here is, if the claimant has HIV, will he or she be considered disabled and eligible for SSI? So there are 2 different ways to argue that they are disabled and eligible. And the first would be by using the listing and seeing if you have all of the ingredients for that recipe, whether you have a doctor's opinion that supports your allegations of disability. And the other way would be to argue based on their age, education, their past work experience, and their current limitations in physical or mental health, that they could not perform either their past work or any other type of work in the national competitive economy. So we'll talk now a little bit about developing strong applications. And in the manual, there are examples of the reports that you have to complete. The medical job reports are at pages 14 to 29. And just as an aside, the listing for HIV is at page 35 and 36. And a report that is specific to HIV/AIDS and is what Social Security calls a medical source statement is at 37 to 38. And that's the form that as advocates or for the clients that we would have a doctor complete that HIV report. So what are the types of evidence that can be submitted? Obviously, we want to obtain and submit all of the medical evidence, the records from any treatment that claimants have received. And if you're applying, today, then I would probably recommend doing, the past 12 months, 12 to 15 months of records, obtain those and submit those. If there is a significant event that happened prior to 2 years, sometimes we have injuries or really serious inpatient psychiatric hospitalizations that can show a pattern of severe impairments, but it goes back further. I would still recommend getting that. So if sometimes clients can point to an incident or an event that is the origin of their disability, even if it wasn't disabling at the time, that injury or incident has worsened now to the point that they can't work anymore, then I think it's important to include that origin evidence as well. So medical evidence is obviously extremely important, but another aspect of the disability application process is obtaining opinion evidence from a client's doctor. So you want to, if you're helping clients with new applications, Social Security is required to consider applications or opinions from all medical sources. And there are some medical sources that are considered more persuasive, and that would be doctors' opinions or psychiatrist opinions, psychologist opinions. Those are the gold standard for medical opinions. And in the HIV/AIDS area of practice, anyone, a doctor who is very, if they work in an infectious disease clinic, if they have specialties related to infectious disease, those are the doctors that we want to give their medical opinions for these applications. Because the more experience and specialization that a doctor has related to the impairment, the better. So if you have someone with a physical impairment, orthopedic impairment, the best is to get the orthopedic surgeon or doctor complete the form. But if you can't get that, then a primary care doctor who is familiar with the client would be the next best. A therapist who has been working with the client, mental health for, basically a therapist would be the next best behind a psychologist or a psychiatrist. What's also important when you're obtaining these medical opinions is choosing treating sources that have the best understanding of what the client is going through. So oftentimes we will see psychiatrists who maybe see a client once every 3 months for medication management, but they're not doing psychiatric treatment necessarily. But what we do have is a therapist who meets with the client every other week, really knows the client's limitations, knows or can give an opinion as to how a client would react in a work situation. Or if you can't get a detailed psychiatric report, then that would be the next best option. And sometimes judges would prefer to see the detailed reports from the therapist as opposed to just a checkbox report from a psychiatrist. So you really want to develop these opinions from the treating sources that know the client best. Other evidence that can be submitted to Social Security would be a social worker's non-medical reports observations. So if you are an advocate that works directly with the client and does so on a regular basis for an extended period of time, your reports and observations must be considered by Social Security in their evaluation. So there are, we did include a report for social workers in the manual as well. Basically just giving your, giving what, observations, what you've seen, the limitations that your client has. You can also submit employee records. So if the client has an employer who was very accommodating, that could write a letter, that's sometimes helpful. Or if the client's file contains information about them being consistently late or absent from the job due to their impairments, that can also be helpful information for the application. And then also, we do have family members, friends, neighbors who know the individual, know the type of help that they need, and know their limitations. They can submit third-party reports or just a letter, a signed, dated letter as well, giving their observations. Social Security also wants to know how your physical or mental limitations affect your activities of daily living. So examples of that are, can you clean your house? Can you cook? Can you perform personal grooming? Are you able to shower without help? Those would be the physical activities of daily living that they want to know whether or not you have any problems doing that. And then also, if you're talking about a mental health impairment, are you able to do that, or do you have days that you stay in bed all day? Can you not concentrate to complete those types of tasks around your house? If you're able to do all the activities of daily living, but you have to do them very slowly, that it takes you all day to clean, that's important to include as well, because most people are able to do these ADLs, but it takes them a much longer time to do them than before their injury or before they became depressed or developed anxiety. Another aspect that Social Security wants to know about is how you function socially. So do you have friends or family that you see regularly? And this is especially important for clients that have mental health impairments, but also clients who have side effects from medications like fatigue, diarrhea, those types of limitations. Are they affecting how you socialize or interact with family members, with the public? Are you irritable when you go out in public? Do you have issues in the doctor's office if you're waiting too long? Giving examples of how the symptoms from your mental health or physical impairments affect your social functioning is very important as well. So as advocates, how can we help our clients? Getting records from the treating source, those opinions are the most important. Social Security can usually get the medical records, but in the meantime, it would be very helpful to your client's case if you can speak with their doctors and see if they can complete the forms for you. And then next, if Social Security doesn't get all of the records, or you just want to go ahead and get those records, that's also very important. And then assisting our clients with filling out the forms. Very important in our practice. I would say that there's an advocate to help them complete the forms and kind of pull out information from clients. And then gathering other evidence from family, friends, or neighbors, or employers. So when Social Security is making their determinations, they're only going to consider whether an individual can work full-time in a non-sheltered, non-supported work environment. And another thing to remember is that disability is not necessarily a permanent disability program. There are some individuals who will be on disability for the rest of their lives, but it's imagined to be a temporary disability program where people are temporarily unable to work, but with treatment and rehab, et cetera, that they will eventually re-enter the workforce. And to move that along, Social Security will conduct reviews of claimants' medical condition to see if they've improved. And that's called the CDR. And that may be something that if you work with longtime clients, you may help them get on disability, and then eventually they'll get a notice that their case is being reviewed. If Social Security determines that they're no longer disabled, then their benefits will cease. They will terminate them very quickly from monthly benefits. How to expedite a decision. If you have clients who are in desperate need of disability, I mean, all of our clients are in desperate need of disability, but if there is something like a terminal illness or dire need cases, you can push for an expedited decision. Not only the terminal illnesses, the TERI cases, There are also categories for compassionate allowance. So those are clients who are have such severe impairments that it's likely to result in death, although they haven't been diagnosed with a terminal illness yet. A recent example from one of my cases is glioblastoma, so a brain cancer. That is part of the compassionate allowance category. They give you a full, and this is again on SSA.gov, they'll give you a full list of diagnoses that could be considered under the compassionate allowance program, and those decisions should be expedited. The other category would be financial emergencies. So if someone is homeless or facing bankruptcy and could use that money to pay for shelter or to pay their bills, that will also be considered when you request an expedited decision. I would say that is the least likely to be successful, unfortunately. Especially in clients who are homeless, it should be more of a priority, but I think that Social Security focuses on the Terry cases and the compassionate allowance cases more so than the financial cases. To give you an idea of what your appeal rights are and the time limits to appeal, we've got in the manual a full list of the deadlines to appeal. But in New York State, in January of 2019, they added another level of appeal, another level of review, which is called reconsideration. So if you apply for a disability and are denied disability, you have 60 days to ask for a reconsideration. The reconsiderations are considered within a New York State agency. So the initial application and this reconsideration appeal are part of a New York State agency review. If you are denied reconsideration review, then you appeal to the level of an ALJ hearing, an administrative law judge hearing. And that also must be done, requested within 60 days in written form. You can file that appeal online at SSA.gov, and that goes for both the SSD and the SSI program. So whereas you can't apply for SSI initially, you can file an appeal online. And the claimant has a right to be represented at the hearing by an advocate or by an attorney. If a client goes to a hearing with the judge will advise them of their right to be represented. And if the client chooses to look for representation, the judge is required to give them a postponement and adjournment, more time to find an attorney. And of course, we highly recommend that clients have a lawyer or a paralegal advocate in the hearing with them, and also just to develop the case before the hearing. Some of the judges are, this is meant to be an impartial, non-adversarial process, and that is respected by many judges, where a judge will obtain medical evidence, will fully consider a case, but you do come across judges who are not as considerate and are not considering the case as thoroughly as they should. So that is why an advocate or a lawyer is important. So if you go in front of the judge, the judge is really your only in-person appeal. It is really your only chance to appear in front of a person and argue your case. And that is we have the highest rate of success at ALJ hearings, but it's still about a 60% approval rate at that level. So there's a significant number of denials at the ALJ level. And after you receive a denial, there is another level of appeal. You can appeal within Social Security to what they call the Appeals Council. And this is basically just a review of the judge's decision to see if any errors were made. Did they ignore certain facts or evidence, or did they apply the law incorrectly? They're not looking to relitigate the case. They're really just looking to approve or send back the claimant to the same judge to fix the decision. Again, this is a 60-day deadline to ask for a review. The Appeals Council only remands or sends back cases in about 15% of their reviews. So if you're denied by the Appeals Council, which is likely, you have the next option, which is federal court appeal. And that is basically suing Social Security to do their job, to apply the law correctly, to make sure that the facts were decided correctly in the case. At the same time, if you're denied from Appeals Council, you can reapply. You can do a new application, go back to the beginning, start over with a new application. And you can do that at the same time that you appeal in federal court. Now, federal court cases are all on paper, they're all legal arguments. So again, you're not going to be appearing in front of a judge at the federal court level, but you can continue that application by appealing in federal court. And at the same time, you can have a new application started at the initial level. So other decisions by Social Security that can be appealed are those CDRs that we talked about, the continuing disability reviews. Fleeing felons, if Social Security has decided that you have a warrant for your arrest and you are under their definition of fleeing felon, you can appeal that as well. You can also appeal a determination of resources. So a lot of times we have clients with a random piece of property that Social Security decides is worth, $16,000. If we can counter that with evidence of, evidence that one, they can't sell the property and that it's not worth as much as Social Security determines it is, then you can overcome that resource determination. That does take a little doing. It's not, resource appeals are not usually successful when you're looking at real property. If people own a piece of property that they forgot about, or that they own in conjunction with several siblings, it's very hard to overcome that determination, but it can be done. Social Security will continue to pay you benefits in certain situations while you're appealing their determination. So if there is a continuing disability review, for example, and they determine that your client is no longer disabled, if you make a request in writing to Social Security within 10 days, they will continue to pay your client's benefits during the appeal. So, it's a very strict time frame. It's not the 60 days to appeal. It's a 10 days to continue your benefit. If there are determinations that say they're no longer eligible for the full benefit rate, if you appeal that, they are required to continue to pay you the full benefit rate until they make a decision as well. So there are situations where a client can continue to receive the full benefit amount while they're appealing a determination. Okay, so an example of a case where resources comes into play is this individual is 45 years old, single, who lives in a home that is worth about $80,000, but there's no mortgage. He doesn't owe anything on it, and has about $200 in the bank. He owns a car worth $2,500, and he works part-time collecting tolls, although I don't know if those jobs exist anymore, but he works part-time and earns about $285 per month. Will Chris T be eligible for SSI benefits with these factors? He should be eligible for SSI benefits. And you are, the house that you live in is exempted from a resource consideration. So that is excluded. He only has $200 cash in the bank. So he hasn't reached that $200 limit for SSI recipients. And then he owns a car that is worth $2,500. Now, one car is also excluded from a resource consideration. So that car would also be excluded. So he knocked out the house, he knocked out the car, he only has $200 cash in his bank account, and he's only earning $285 a month. So he would be financially eligible for SSI because he doesn't exceed the income limit and he doesn't exceed the resource limit. Now, whether or not he meets the medical determination qualifications is the next question. So Mr. T was diagnosed with HIV and AIDS in 2015, and that was as a result of the T-cell count being below 200. He had previously worked as a dishwasher and prep cook, but he stopped working in January 2018. A few months later, he was hospitalized with pneumonia, and he stayed in the hospital for 4 days. His current symptoms include fatigue, diarrhea, night sweats, occasional thrush, muscle pain, and depression. What you would do in this situation is look at that listing of impairment and decide whether or not he meets the criteria for the listing. Does he have all of the ingredients that would make him eligible for SSI SSD? And just briefly, I don't have the manual up in front of me, but the criteria for that listing is generally stricter. So he may or may not qualify under the listing. He doesn't meet the requirement for hospitalizations, which has to be 3 hospitalizations, 48 hours each, 30 days apart within 12 months. According to this hypothetical, he only has 1 hospitalization, which would meet the duration requirement, but he needs to have 3 of those. So if we go back to the T-cell count in the listing, if you have the T-cell count below 200 and your BMI is below 18.5%, or your hemoglobin is less than 8 grams per deciliter, then you should qualify and meet or equal the listing. And then if you consider his other symptoms, fatigue, diarrhea, night sweats, those also may qualify him for disability. So you just have to go through each section of the listing and see if you can find evidence in the file to meet those criteria. And if you can, then he could be found disabled early on in the process. if you don't think that he meets it, or Social Security determines that he doesn't meet that listing or equal that listing, then you go on to consider whether or not these symptoms and the possibility of him being hospitalized would make it so he could not perform his past work, and that he would not be able to perform any other type of work as well. So can he get SSI? You would need to help him file his application with those medical records, with a form specifically for HIV/AIDS that would be completed by his doctor, preferably infectious disease doctor. And you gather all of the medical records of hospitalizations, any treatment that provides information about his limitations, any PT records, etc., that would help support the application. And then you determine whether or not he meets the listing, as we discussed, or whether or not there are other ways to find that he's disabled by showing that he has limitations in his ability to take care of himself, that he has limitations in his ability to concentrate and complete tasks, or that he would be absent or late to work because of his symptoms, including depression, anxiety, and in combination with his physical limitations. So I would encourage you to take a look at those, at the manual generally. It gives a more detailed description of what I've discussed today, but then it also has the reports that you would be completing to submit an application, and it has the listing of impairment for HIV/AIDS and an HIV/AIDS specific report to be completed by doctors. I think I am at the end of the PowerPoint, so if anyone has questions for me, I will be happy to answer them.
Thank you, Jennifer. We did have some questions come in. I don't know if you have visibility to those. If you click on your chat box, you might be able to.
Let me see. It's in the chats, or it's in?
Or I'm sorry, I misspoke. In the questions.
I'm having a hard time seeing it.
Okay, I'll just read them to you.
Okay. Oh wait, maybe okay, I can see it now. So one of the questions is, what will happen if a client has been denied SSI, SSD due to their status? Will they need any kind of proof to state that they have HIV? Yes, they will need to provide a diagnosis of HIV/AIDS. It can be, from 20 years ago, as long as they have something that shows that they have that they are HIV positive. That should suffice. If they don't have a diagnosis going back, if it's been 20 years since they were diagnosed, you can use a current doctor who has adopted the diagnosis, and there's evidence that they've been on medication and been receiving treatment for however long they've been receiving treatment. So are there more than? Okay.
There's another question. Are stimulus payments counted towards income?
So the stimulus payments were not to be counted towards income. There may be I'm not entirely sure. I can check, and if you want to send us privately your email address, I can double check on that, but the stimulus payments were supposed to be excluded from consideration of benefits. Sometimes they will exclude it for a period of time, 9 months or 12 months, and that's how they exclude tax returns. You have a 12-month period to basically spend it and get below that income resource limit. So The short answer is yes, but I just don't know the details of how long it's exempted for, how long it's excluded.
Okay. Here's another question. What would happen if the applicant is aged but has work history and a degree?
Has work history and a degree?
Yes.
So if they're an older individual with an advanced degree and a significant work history, Social Security will consider whether this individual could do other types of lesser skilled work. So if they have a master's degree in teaching, for example, are they able to do something, and they have, for example, a traumatic brain injury and have lost some of that, the skills that they used in their previous work, could they do lesser skilled work? So just because you have a PhD, master's, bachelor's degree doesn't mean that you won't be eligible for disability, but it does mean that Social Security may consider lesser skilled jobs that an individual could do if they're unable to do their past work.
Okay. The next question is, are the clients eligible for Ticket to Work program as well? Will that affect their benefits?
So the Ticket to Work programs, I don't have a lot of experience with the Ticket to Work programs, but what I do know is that if you're enrolled in a Social Security approved Ticket to Work program, which, I mean, that's their program. So if you get in with Access VR or another vocational rehab program and you're working with them, you should be protected from continuing disability review. So if you're in that program, you're working with them, you have some protections against losing your benefits. Now, it's not necessarily, there are other regulations which take a look at how much money you're making every month in those programs. The more, for us, the more important protection is that you're not going to be reviewed. You should not be reviewed if you're participating in those programs. But as far as income, whether the income from working with those programs goes against your disability, that would be part of a different consideration. It's kind of confusing because under the disability program, they give you an opportunity to earn income to see if you can re-enter the workforce. And there's very specific rules for working and being on disability. But there are programs out there that are basically disability employment navigators. And if you're in New York State, Social Security does pay for programs and advisors to make sure that you're following all of the rules while you're working and receiving disability. So again, if you want to send your email or something, I can send you links to those programs. And we highly encourage clients who are working and receiving disability to check with those individuals, those advocates, to make sure that they're not violating any of the Social Security work program rules.
Okay. The next question is regarding the timeline on decisions. How long does a federal decision take?
A federal court decision, like I said, the initial application takes about 3 to 5 months. The reconsideration level takes about 3 to 5 months. And then the appeal to be in front of a judge can take anywhere from 6 months to 2 years. If you're denied there, then you go to the appeals council. That can be another year of waiting. And it's the same for federal court appeals. We give an approximation of about a year for a federal court appeal. So really from beginning to end, I would say at least 2 to 3 years of waiting for an answer. And sometimes longer. I have cases that we're just now getting federal court decisions that they filed an initial application in 2014, 2015. So it can take a long time.
Okay. And I'm not sure where this must have been the question earlier in the presentation about bank account limits. They're asking, what is the bank account limit?
So bank accounts are limited to, it's part of the resource determination. You have to stay below $2,000 if you're an individual. If you are married or holding out as married couple, the limit is $3,000. So that would include any amount in a bank account, but also any other cash or bonds or anything else that can be liquidated into cash. That's what they will look at. But basically, if all you have is a bank account, it has to be less than $2,000 in any month to receive SSI.
The next issue or question is, someone writes in that they've been seeing cases where clients do not receive the initial SSI termination notices, so they don't have an opportunity to request reconsideration within 10 days to have their benefits continued during appeal. Have you seen this? How have you dealt with it?
So we have seen this during the pandemic. There has been a lot of lost SSA letters, and there are several messages, guidance from Social Security that advise the local office, the hearings offices, to find good cause in those situations to continue the benefits or to accept an appeal after the 60 days. So if you are seeing clients with who didn't receive determination letters, or just under normal times, if they weren't able to appeal within the time frame because they were incarcerated or they were in the hospital, there is a request for good cause to accept the appeal or to continue the benefits. Obviously, you want to provide Social Security with an explanation of what happened, and doing a statement by a claimant that they did not receive the determination letter should be enough during this time. They are being told to be very generous with their good cause waivers for timing. So you should be able to have those benefits restarted, even if it's after the 10 days. And also, if you're seeing clients who did not appeal within 60 days, then you should, if there is some sort of good cause, then they should accept it much more liberally than they have in the past.
The next one is, if a client is declined due to lack of paperwork, which is the fault of their primary care physician having delays, can they appeal on their behalf?
Yes, you can appeal for any reason. I mean, the appeals are basically saying that we are still disabled. Now, if it's not just the claimant's responsibility to get the medical records, Social Security also has a responsibility to develop the record. So if Social Security did not obtain the records, or if the physician did not send them in a timely manner, you can certainly appeal. And if you believe that you have very strong records that they either meet the listing or they are so severely limited, and it shows in these records, you know, I would probably suggest advocating to have them reopen that denial, or if you can get it in front of an analyst at the reconsideration phase and explain that Social Security did not have these records at the initial determination, then you should be able to have them consider those records.
Okay. And this is another question relating to the stimulus. Do you know how a person can get his stimulus check? Apparently they never received one and tried to go online without any success.
Yes, depending on where you are in New York State, there are organizations that can help clients file for their stimulus. Right now, I believe that you have to file a very abbreviated tax return. If you were not in their system, if you weren't receiving SSI or SSD benefits, if you haven't filed tax returns recently, then you have to proactively give them your information and do an abbreviated tax return. There are VITA sites, the free tax prepare sites that are funded by the IRS that may be able to help clients file. But again, if you need additional information, I can send you referrals and links and directions on how to help your client get the stimulus funds if they haven't received it yet.
And someone else writes in that they had a client that had a voucher for back to work program. A year later, they contacted and said that they had overpaid him.
Yes. So the overpayments are also an appealable determination. If your client was in an approved Ticket to Work program, if they were actively participating, then they should not receive an overpayment. However, like I explained earlier, there are different rules that apply to someone who's working and receives disability benefits. So if you need information on those work rules, that is, you would want to talk to someone in that New York State program that works with individuals who are working and receiving disability. But that is something that you can appeal within 60 days, but you can also ask for a waiver of the overpayment if it was no fault of your clients, if they believed that they were enrolled in an approved program and they were participating and meeting all of those requirements, you can ask to have that overpayment waived. So that is also, that's an appealable decision along with like a CDR, the continuing disability review. Those overpayments can be appealed, and I highly encourage people to appeal those because oftentimes they had no idea they were being overpaid and it wasn't their fault. They were reporting all of their earnings, etc. And the local office does have the ability to waive those up to a certain amount. And if they refuse to waive it, you can go in front of a judge and make the argument that, that you shouldn't have that overpayment deducted from your check.
Okay, looks like we've got about 4 more questions. The next one says, if a client has been receiving benefits and passes away, do the children or spouse get the benefit? Even next to kin, do they get benefits?
So that depends. Generally speaking, an SSI benefit will not continue to receive any SSI benefit. There's no benefits for children or spouses upon the death of an SSI recipient. If an SSI recipient or if an SSI applicant dies while they're waiting to get benefits, then a spouse can receive retroactive benefits if they're found, and they should be found disabled if they passed away from their disability. Then a spouse can receive benefits for the time that they were waiting for the approval up until the time of their death. So from application to death, a spouse can receive SSI benefits. Otherwise, those benefits stop at death. Now, with SSD benefits, there are certain situations that that children and spouses can continue to receive benefits, but those are, again, very specific rules. So I would say it depends on the situation, and if you have a specific client situation, please email us and I can respond to it specifically. But there are options and programs to continue to receive benefits upon death.
Okay. The next one is, what happens if an individual receives money from a settlement? For example, $5,000 from a car accident. How's that counted?
So for SSI, that will be considered against your resources and possibly your income in the month that you receive it. And then after 1 month, it will be converted as a resource. For SSD, it doesn't matter. But for SSI, it will be considered, and you may be ineligible for a couple months until you spend down to your resource limit of $2,000.
Okay. I'm just reading here. If someone is taking antiviral medications and deemed not detectable, are they still eligible?
Definitely. Well, I think most of our clients, it definitely doesn't exclude them from being found disabled if it's undetectable. Most of our clients in the past 10 years are undetectable because of the advancement in treatment. But what can affect clients and can be considered by Social Security are side effects from medications. I think that's most commonly what I see now are clients who are HIV positive but have not, but have significant side effects from medication. So you have the diagnosis of HIV/AIDS, but then you may not have symptoms specifically from the virus, but you can have side effects from the treatment, and that will be considered by Social Security. Now, are the side effects from the treatment, is that enough? It really depends, but oftentimes we have clients who also have developed arthritis or cognitive impairments from the treatments as well. So you really need to speak with the client and speak with their doctors about the symptoms that they experience, but also side effects from the medication.
Okay. Where would one find a disability navigator to explore one's options for Ticket to Work?
Ticket to Work, you can really just go online at ssa.gov, and Social Security should send clients information about Ticket to Work programs. In fact, I think they do regularly. But if you haven't received brochures or information about different places that are approved as Ticket to Work locations, you can go online and at ssa.gov website, and they will direct you to your local organizations that are part of the Ticket to Work program.
Okay, and finally, we'll go back here. Briefly, can you go over the current process again for applying for SSI? Is it all done over the phone and then paperwork has to be mailed?
Yes, that's exactly right. So for SSI applications, you must call into that 800 number or to the local office number and do applications over the phone. Once you complete the phone application process, they will mail you the reports to complete, and those are the most important. The most important reports are those initial reports to make them as specific as possible. At the same time, you can submit medical records as evidence. You can submit those medical opinions as important medical source statements that Social Security must consider. So it's a combination of phone and then paper through the mail, so snail mail.
Okay. There was a bunch of questions, lots of good questions today. So thank you to everyone who wrote in. I don't see any other questions coming in.
Okay, well, thank you all very much. And like I said, I have my email on this last slide. So if you have more, if I haven't answered something or you need clarification, especially around the stimulus, we have a lot of information on how people can obtain the stimulus. I can also send you information on how it is considered by Social Security. Please shoot me an email and I will get you the information. But thanks very much for listening to the presentation today.
Yes, thank you for being with us today. And just a reminder to everyone to complete the evaluation form and give us your feedback. And have a great rest of your day. Thank you.